also going to be broadcast online. There's a webinar of the American Society of International Law available to American Society of International Law members around the world. We may get some questions online from people who are watching online. But otherwise, of course, you guys will be, when we get to the Q&A session, will be encouraged to ask questions as well. So I'm going to, I'll formally start the webinar here in just a moment. All right, Jimmy, so whenever you're ready. All right, well, I'd like to welcome everyone to the inaugural webinar of the American Society of International Law's Rights of Indigenous Peoples Interest Group, which is being hosted here at Lewis and Clark Law School in Portland, Oregon. My name is George Foster. I'm a professor at Lewis and Clark and the co-chair of the interest group. So before I introduce our distinguished panel, I wanted to just very briefly set the stage for the discussion by giving you a brief introduction to the topic that we'll be engaging today, which is realizing international indigenous rights in domestic law. So in recent years, there have been a number of instances in which the international community has recognized that indigenous peoples around the world possess certain inherent special human rights. And one of those forms of in which the international community has expressed that is an instrument known as the United Nations Declaration on the Rights of Indigenous Peoples, which was adopted by the UN General Assembly in 2007. Now, it was this declaration expresses a wide variety of rights of indigenous peoples, dealing with such issues as self-determination, sovereignty over natural resources, recovery of traditional lands, protection of their cultural and spiritual heritage, economic development, environmental protection, and so on. Now, UNDRIP was adopted overwhelmingly by the UN General Assembly. There were only a few countries that voted against it. The United States was one of them under the Bush administration. And since then, since it was adopted in 2007, all those countries that voted against it have changed course and have come forward and endorsed it again, including the United States under the Obama administration. Now, UNDRIP by its terms is expressly non-binding. However, it also provides that any country that endorses it should strive to realize the rights that it expresses. And when President Obama endorsed the declaration, he pledged the United States to do precisely that. And so what our speakers are going to be dealing with today is basically bringing us up to speed on what has happened since then, what are the challenges involved in implementing this instrument into domestic law, translating it into action on the ground, the challenge of balancing these very important rights of indigenous communities, balancing those with the broader public interest in society. Our first speaker for today will be Walter Echo Hawk, who is the Chief Justice of the Supreme Court of the Kickapoo Tribe of Oklahoma. He's also of counsel at the law firm Crowe and Dunlevy, and a visiting professor this year at Lewis and Clark Law School. Now, Walter has represented Native American tribes, Native Hawaiians, and Native Alaskans for more than 40 years in many important cases involving issues like religious freedom, treaty rights, repatriation, and reburial rights. He's also the author of several books, including books on international human rights. His most recent book is called In the Light of Justice, the Rise of Human Rights in Native America and the UN Declaration on the Rights of Indigenous Peoples. It was published just in a couple years ago, 2013. So Professor Echo Hawk will discuss, basically he'll bring us up to speed on what's happened since the Obama administration's endorsement of the Declaration, and we'll talk about the relevance of UNDRIP to the future development of U.S. law. We also have Brett Kenney, who's the General Counsel of the Coquille Tribe of Oregon, who represents the tribe in a wide range of issues, including natural resource development. And he's going to talk about the recent experience of the Coquille Tribe and some of their aspirations with regard to recovery of traditional lands and management of co-management of federal timber resources. So he'll discuss the potential relevance of the Declaration to those aspirations. And then finally, we have Nicholas Fromherz, who's a visiting assistant professor here at Lewis and Clark. So Nick, after graduating from law school, he clerked for a pair of federal judges and practiced civil litigation in California. Before he moved to Bolivia, and he worked on environmental issues, including soil conservation and resolution of environmental conflicts. He also taught public international law while he was there. And while Nick was there, he became fascinated with a particular project, which was very controversial, involving the construction of a road through an indigenous reserve in Bolivia called Tipnis. There was a lot of controversy surrounding that project and the consultations that took place. And so Nick will be sharing some observations about that experience and giving us a sense of some of the challenges that countries like Bolivia face in trying to implement the Declaration. So after each presenter is finished, we should have some time left for question and answer. So those of you who are present, of course, can answer a question directly. And those of you who are watching this online, you should please email any questions you may have to events@azl.org, and there'll be an AZL representative standing by there, and forward your questions to me so that I can then pose them during the question and answer session. All right, well, without further ado, I will turn it over to Walter Echo Hawk.
Good morning, everybody. I'm very glad to be here from Portland, Oregon, at Lewis and Clark Law School, and I want to thank you, George Foster, Professor Foster, for putting this together, and also the law school here at Lewis and Clark. I also want to thank the American Society of International Law for their sponsorship of this forum. I'm very, very honored to be here to participate on such a distinguished panel. And I'm excited to talk about our subject today because I feel like the subject of implementing international indigenous rights into domestic law, particularly in the United States, I think there might be a big role for the American Society of International Law to play in that process, and perhaps educating the domestic bar about international law and international human rights law. So hopefully out of this panel might come some interest in collaborating between the American Society and our domestic practitioners of federal Indian law as to how we might go about implementing these UN standards into domestic law in the United States. My topic on the panel is realizing indigenous rights in the domestic law of the United States. And I want to look at the potential impact of the UN Declaration on the Rights of Indigenous Peoples on federal Indian law and policy here in the United States. And so what I want to do is I want to cover about 4 areas briefly here. First, to think about how indigenous rights that come to us today from modern international human rights law, as embodied in this UN Declaration and its standards, may impact the future of federal Indian law and policy. And to do that, I want to look briefly at our existing a legal framework for indigenous rights in the U.S. Secondly, to briefly look at the human rights framework that's provided to us by this UN declaration. And then thirdly, to look at some of the implementation challenges, I think, that face our nation in basically entering a brand new era of human rights law for our indigenous law policy here in the U.S. So with that, let me turn quickly to federal Indian law. That is our existing body of law in the United States for recognizing Native American rights. It's our current legal framework for defining the rights of Indian tribes and Indian peoples, Alaska Natives, and to some extent our Native Hawaiians, which these three groups comprise the indigenous peoples of the United States. This legal framework lays out the political status of our Indian tribes in our political system. It defines the rights and responsibilities and relationships between American Indians and the United States government and among the states as well. The sources of this body of domestic law include international law, 360 treaties between Indian nations and the United States government, probably 1,000 or more U.S. Supreme Court decisions, thousands of acts of Congress pertaining to Indians that are codified in Title 25 of the U.S. Code, administrative law pertaining to agency actions with regard to Indian tribes, as well as tribal law, that is the law, traditional law, and contemporary law promulgated by tribal governments. From these sources, these diverse sources for federal Indian law, we can see in this legal framework both some protective features and also some features that tend to undermine these protective features. And in looking at the protective features here, I'm referring principally to the Supreme Court common law doctrines of inherent tribal sovereignty, as well as the Protectorate Principles that were announced by the Supreme Court in Worcester v. Georgia by Chief Justice John Marshall's opinion, 1832, that lays down the foundational principles of federal Indian law that still obtain in large measure today. These protective features, inherent tribal sovereignty and the associated protectorate framework, are very strong and vibrant features that recognize the inherent tribal sovereignty of self-government in our political system, exercised by Indian tribes under the protection of the United States government through our treaties in a relationship very similar to an international protectorate that existed in John Marshall's day and still very familiar in international relations today. Within these protectorate features that require our government to honor treaties with Indian tribes, to protect the self-governing rights of Indian nations, to enforce these treaties, as well as to have barriers between state jurisdiction and tribal reservations. We have witnessed the rise of our modern Indian nations here in the United States during the modern era of federal Indian law from, say, about 1970 to the present. These protective features for many years lie in the law, but they lie dormant, pretty much so during the 19th century and much of the 20th century until basically the modern era, when we work to try to breathe life back into the protective side of federal Indian law. And with the support of President Nixon and the Indian self-determination policy of the government, we were able to coax the courts here in the United States into applying these protective features in a modern day setting, and that led to this very stirring rise of our modern institutions that we've seen in the last 30 or 40 years. This framework also has a dark side to it. That is the law of colonialism, drawn from early international law by the U.S. Supreme Court during the early decades of our young republic. It's comprised of doctrines such as the doctrine of discovery, doctrine of conquest, Victoria's Law of Nations guardianship principles, the just war doctrine, the doctrine of plenary power. These legal doctrines and principles have very distinct anti-indigenous features, along with associated legal notions of race and racism overtly, according to Webster's dictionary book. And so this is a dark side of the law that is still with us today. It was implanted by the Supreme Court in a series of cases that have never been overturned, that are still relied upon today, and our legal scholars have very clearly identified these doctrines in the so-called dark side of our legal framework, and directly traced these doctrines back to medieval Europe and early settled principles of national law. And so we have a whole bevy of a long line of Supreme Court cases like Johnson v. McIntosh, Lewis v. Hitchcock, Sandoval v. United States, Teton case in 1955 that espouse these principles and are still relied upon today by the Supreme Court to decide issues. And so that is the current state of federal Indian law today in the year 2015. We see some problems in this body of law arising from this dark side of the law that has created some internal tensions within this legal framework between the protective features and these other features that strive to undermine that regime. And Native America being caught in between this internal tension in the law. And so I think our current legal framework is not working as well as it could, and I think it could benefit from certain improvements there. And I think one of the questions, big questions confronting domestic practitioners is, what to do with this dark side of the law that's still with us to this very day. And we see manifestations of this problem by the Supreme Court trend since 1985. Our Indian nations have lost 80% of their cases before the Supreme Court. That's on a judicial trend towards trimming back on our Native American rights here in the U.S. So I would submit that there is a need for reform, and many of our scholars in this field, a growing number of scholars have indicated a need to reform and strengthen this body of federal Indian law, make it a more just body of law, more suitable for the 21st century. So now we have this UN Declaration on the Rights of Indigenous Peoples that was approved by the United Nations in the year 2007. And it creates it was almost 30 years in the making at the United Nations. It was developed during a very historic period, a very historic time in modern international human rights law, when that body of law was experiencing very dramatic growth, especially in the human rights field, with a focus on indigenous rights since World War II. And the UN basically developed this Declaration on the Rights of Indigenous Indigenous peoples during this time this body of law was growing. And basically the Declaration looks to this modern body of modern international human rights law. That is the long list of UN human rights treaties, the norms and emerging norms and customary international human rights law, and draws from that body of law these principles that they put, that the UN put into this declaration to show nation states or member nations how to apply the larger body of human rights law in the unique situation of indigenous peoples, so that the indigenous peoples can get the same kind of inherent human rights that the rest of humanity already enjoys and takes for granted under modern international human rights law. So, because of the linkage between these UN standards and the larger body of international law, we have a set of standards now that have very high normative value. The International Law Association in 2010, under the chair of Siegfried Wiesner, looked at the normative value of the Declaration in a paper that it produced in 2010. And many of these norms or standards are norms and customary international law, which means that norms and customary international law become part of our federal common law here in the United States. So it seems that we have a set of standards that are technically, I think, a part of our federal common law now. But the Declaration, of course, is a non-binding instrument, international instrument. The UN asks every nation that endorses it to take affirmative steps to implement these human rights standards and associated duties in partnership and in consultation with indigenous peoples to provide technical assistance in that process, funding, and so on and so forth, to develop effective measures to implement each and every one of these standards. And so that presents a pretty big challenge, it seems to me, to do that. But I believe, as a practitioner of domestic law here in the United States, that these UN standards may be a tool towards strengthening and reforming our existing body of federal law. And knowing that international law has always shaped federal Indian law, and I think that in the early days the Supreme Court looked to international law, borrowed from it in whole cloth, and now in the modern era it needs to continue that process in importing these human rights principles into our legal framework at this point in history. So as we look to implementation challenges, how am I doing on time? 5 minutes? We can look around the other nations. There's 150 nations around the world that have endorsed this UN Declaration, many of which are now in the process of various stages of implementing these standards into their domestic law. Up in Canada, for example, we can see today that this UN Declaration has been being discussed in 19 reported opinions in the Canadian courts up there, and litigation brought by the First Nations to try to begin a judicial discourse about importing these human rights standards into Aboriginal law up in Canada. Also in Canada, we see there's a bill that's pending in the Canadian Parliament that would lay out a national plan for implementing these standards in Canada. It's passed the second reading in Parliament, so Canada is sort of more quickly up to speed on the human rights and possibilities of this UN Declaration. than I think we are here in the United States. We can look to Bolivia, which has already enacted a national law incorporating this declaration into the domestic law of Bolivia. We can look to some of the international tribunals here in the Western Hemisphere, particularly the Inter-American Court of Human Rights, which was created by the OAS, American Convention on Human Rights, and it is handing down a bevy of cases that lay out human right norms for indigenous peoples, land rights, cultural rights, and building up a significant body of international human rights jurisprudence for our hemisphere here. But here in the United States, progress has been slower in embracing the standards, even though we do have these problems in the law that I've alluded to, even though there are gaps between our existing law and policy and these minimum human rights standards in many important areas. And even though international law has always shaped our legal framework here, I think there's been a historical distrust of international law in the U.S. And the United Nations, and certainly most of our domestic practitioners are unaware or not versed in the practice of international law. So we have no cases to date, even though we've endorsed this since 2010. We have no cases, reported cases regarding the declaration. We have no national project devoted to implementing these standards. There's been no national plan developed by the government for implementing these standards, and there's no national discourse in our country about the nature and content of human rights for Native Americans in the same way that we debated that question for Black Americans. But I think it's important that our country embrace these standards as a world leader on human rights with a very solid human rights heritage. It's American as apple pie. And to date, just briefly, the U.S. has endorsed it, as I've said, this declaration in 2010. The U.S. Senate has held an oversight hearing about the policy implications of that, 2011. 2012, the UN conducted a special mission to the United States. The UN Special Rapporteur, James Anaya, who's for Indigenous Rights, conducted a mission to develop a report in consultation with the government, Indian tribes, to give us recommendations about how we might go about implementing these standards into U.S. law and policy. And I invite you, if you haven't read this report, to go to your computer and download it. It's entitled The Situation of Indigenous Peoples in the United States of America, August 12 of 2012. And it gives recommendations to all three branches of the federal government, as well as to the states and to the Indian tribes, about barriers that we have, needs that we have, and makes recommendations for taking effective steps here. The executive branch calls for an executive order from the president directing our agencies to embrace these standards in their dealings with our tribes, that the president should carry forward a national plan for reconciliation, to carry the congressional apology to Native America forward, to address some of these persistent, deep-seated problems, that Congress should educate itself about these UN standards, hold hearings on that, act promptly on effective measures to implement these standards, and importantly, that Congress should curb its unilateral exercise of plenary power to limit indigenous rights as not being in keeping with the United States human rights obligations. Very tall order for Congress to voluntarily curb its powers, kind of similar to, I think, the states' rights doctrine, perhaps. And the judicial branch, it recommends that the courts discard these dark side of federal Indian law, these that come from the Law of Colonialism as a legal basis to trim Native American rights, and replace that jurisprudence with jurisprudence infused with human rights values, particularly those that are outlined in the Declaration. So I invite you to read that. It's a tall order, a tall legal challenge. I do feel that the right now we're in a self-education phase here in the United States. We've had as I wind down here, we've had some implementation, baby steps in Washington, D.C. We've had the Advisory Council on Historic Preservation to adopt this declaration into its policy, its work under the National Historic Preservation Act. We've had the U.S. Forest Service cite this declaration in developing a comprehensive sacred sites policy to try to better protect Native American holy places located on Federal Forest Service lands. And we see the domestic bar trying to begin educating itself about the Declaration, and the Federal Bar Association conferences, annual Indian law conferences, like the last two that I've attended. It's been a subject there. There's been several law school conferences on this declaration around the country, CU, ASU, Tulsa University, elsewhere. There's been publications on this subject for the bar. My book, In the Light of Justice, that compares these standards with our existing law and policy to identify gaps. Law review articles, there's some coming out now. One of them is the one by Kristen Carpenter and Angela Riley, entitled Indigenous Peoples and the Jurisgenerative Moment in Human Rights. And these scholars contend that we are now in a rare historical lawmaking or jurisgenerative moment in federal Indian law and policy, because we now stand at a crossroads between two legal frameworks, our domestic framework and this new human rights framework, that our challenge is to try to implement these and merge them, synthesize them, in some fashion here. And I agree with them. I think that we do now stand at a confluence between domestic law and modern international human rights law. And our practitioners of international law, I feel like the American Society, for example, and others, have a big role to play to help educate our bar, it seems to me, about the prospects of merging settled principles of international human rights law with our domestic law. So I think there's a need for education for us practitioners of domestic law on that subject. And I would hope to see some collaboration as we go forward, and sharing of expertise and guidance, on the profession here. So with that, I think that concludes my remarks. Professor Foster, I once again thank everyone and look forward to the remaining remarks of our other panelists. Thank you.
Good morning. My name is Brett Kenney. I'm the tribal attorney for the Coquille Indian Tribe. They're headquartered in southwestern Oregon. Before I begin my remarks, I just want to extend my appreciation to Professor Foster for arranging this event. And I want to say that I'm humbled to be sitting on this panel. It's a very important topic, and I'm happy to be part of it. So I live about 4 hours away driving from here. And today, planets are kind of lined up in a way so that my two daughters, my wife is working today, and my two daughters are going to come home, and they're going to have to cook themselves dinner. And they're old enough to do this, and they're competent enough to do this. But that didn't stop me last night from taking out the box of frozen pizza that I bought for them. And I showed them the box of frozen pizza and said, "This is a box of frozen pizza. And here are the directions. You have to preheat the oven. You have to open the box. This is how you open the box. Take out the pizza. Standing here, rolling your eyes, looking at me. You remove the packaging from the pizza. Don't put the packaging in the oven. Put the pizza in, get it out in a safe way, and turn the oven off, because I love you and I don't want to come home and see you or my house combust." So my daughter says, "Dad, just go." And so that is the theme of my talk today, which is "Dad, just go." I hope that makes sense as we go on. Let's say that you are a Coquille tribal member. You're most likely young. You'll have a high school diploma, but odds aren't very good that you'll have a degree beyond that. There's a very likely chance that you already have some health issues. And there's a very good chance you don't have any good job prospects, and you don't own much. But you are wealthy in stories, because you most likely live in the place where your ancestors lived, live near your family as well. Some of those stories are going to be about your family history. There will be stories about how your great-great-great-grandparents signed a treaty with the federal government, and how that treaty was never ratified by the Senate, never became law. And in the wake of that, your ancestors were marched forcibly hundreds of miles away, during which many of them died. But some of them stayed behind and hid out or married settlers. There'll be a story about how your ancestors were treated like children, how they were given things and then taken away from them, how they had to ask for permission for basic human rights, permission to live off of their land. There'll be a story about how many of them were forced to go to a boarding school, forced to cut their hair, forced not to speak their language or practice their culture. There'll be a story about how in 1945, the court decided that it would pay you for some of the lands that you lost, but only in $1,855 and without interest. And then there'd be the saddest story, which was in 1954, when the federal government passed a law that said your tribe was no longer a tribe, which I looked through the UNDRIP, and I can't find a single article that did not violate it. But in 1989, after intensive, decades-long efforts by the tribe, they were restored by Congress and treated as a tribe again. I like to sometimes think of Indian law as a social, kind of an evil social experiment. I say that tongue in cheek. That there are efforts to decide whether to assimilate Indian people, whether that would be the best thing to do, or whether to enhance the tribe's ability to provide for Indian people themselves as a government. And right now, the arc of the United States federal law and paradigm of the UNDRIP is in favor of the latter, that we treat tribal governments as the seat of power in the Indian country, and we try to empower them to provide for Indian people, rather than trying to force Indian people to assimilate within a larger economy and society. But how can you self-determine when you're a restored tribe and you don't have any land, you don't have any money or resources? Well, the Coquille Restoration Act that Congress passed did something remarkable. it called on the Bureau of Indian Affairs to develop a self-sufficiency plan for the Coquille Indian Tribe. And the Bureau of Indian Affairs, in fact, did just that. They adopted a plan in consultation with the tribe that called for the restoration of some of the tribe's lands, 59,000 acres of the tribe's lands in southwestern Oregon. Unfortunately, due to local political pressure, that land that was ultimately transferred was only 5,400 acres, less than 1/10 of what the self-sufficiency plan called for. What's more, the land that was transferred, which is now referred to as the Coquille Forest, has the most restrictive forest management regime of any Indian forest land in the nation. It has to be managed under the standards and guidelines of Northwest Forest Plan, as well as other federal environmental laws. No other Indian forest in the country has to do that. Congress authorized any member of the public to file a lawsuit to enforce compliance, management compliance with those requirements on the forest. So any member of the public that is considered the effective public may file a lawsuit to do that, even if they don't live near the forest or in Oregon or in the West. And now it's happened twice since 1996 when the law was passed. So each time that happens, in the middle of one right now, when there's a lawsuit filed, revenue stops. The revenue that goes to pay for essential government services stops. And I'm talking about basic health care, basic education, and housing. So Indian lands are sometimes held in trust. And when that happens, lands like the Coquille Forest, the federal government is the legal trustee, and the tribe or Indian individual is the beneficiary. And case law tells us that these lands have to be managed by the trustee, similar to how a private fiduciary manages a private trust, with all the duties, duty of care, for example, or duty to maximize revenue. In fact, the federal government can even be held liable in certain circumstances for violating these duties, monetary liabilities. At the same time, the National Environmental Policy Act, or NEPA, creates an environmental review procedure that all federal agencies have to follow when they make federal decisions or perform federal actions. And a tribal timber sale is a federal decision. It's not a federal decision because it involves federal assets. It's not a federal decision because it involves federal lands. It's because it's a federal official making the decision. So for every Coquille tribal timber sale, the Bureau of Indian Affairs has to conduct an environmental analysis, has to invite public participation. Why? Because the trust responsibility has a concept that goes with it called inherently federal functions. And there are certain things that the trustee does that under current federal law cannot be delegated to the tribe. Tribes, one of the great things about our modern state of Indian law, self-determination being the overarching policy, is a lot of the functions that the federal government used to do, a lot of the paternalistic things, are now being performed by the tribe. And that's a good thing, but certain things cannot be performed by the tribe today. For example, the tribe cannot approve environmental review documents, cannot approve a finding of no significant impact, or EA, for example. The tribe can't approve a timber sale. Only the federal government can do that, and the federal government has to comply with NEPA. And NEPA requires that there be environmental analysis and public participation. For the Coquille Forest, the public has been defined as the general public. So you have this paradox where, or conflict. On the one hand, the BIA is the trustee of these lands, charged to make decisions based exclusively on the tribe's best interests. And on the other hand, NEPA requires the Bureau to make decisions based on different different environmental and social factors, and public input. Sometimes the duties of a trustee coincide with those of the NEPA requirements, and sometimes they don't. I think there's a second underlying conflict that reveals why this apparent conflict exists, and that is that the overarching policy of the federal government and the cornerstone of the UNDRIP is this concept of tribal self-determination. But the NEPA regime itself denies tribes the opportunity to conduct their own environmental review and allows the unaffiliated public to influence those outcomes. Just to emphasize, we're talking about lands that the tribe owns. These are tribal lands, not federal lands. Both of these anomalies can be resolved by authorizing tribes to adopt tribal environmental review laws for themselves, or TEPAs, Tribal Environmental Policy Acts. There's already precedent for tribes to do this under the Hearth Act, federal law right now. Tribes can adopt their own tribal environmental policy laws, and they can review, they can conduct environmental reviews for leases of trust land. And there's a growing number of tribes that are taking advantage of that, especially under the Obama administration. To extend that model to Indian trust assets, especially assets that generate critical government revenue for the tribe, would be consistent with the UNDRIP. And I'm thinking specifically of Article 20, which recognizes the right to be secure in the enjoyment of Indigenous people's own means of subsistence and development, and to engage freely in all their economic activities. In Article 21, the right to improve their economic and social conditions without discrimination. And I'd also note that Article 29 states in part that Indigenous people have the right to the conservation and protection of the environment and the productive capacity of the lands or territories and resources. I'd like to say a few things about tribal management, co-management, and non-tribal lands as well. In preparing for this, I read Article 26 of the UNDRIP, which I think is just really interesting. It says, I'm just going to read the first paragraph from it. It just says that Indigenous peoples have the right to the lands, territories, and resources which they have traditionally owned, occupied, or otherwise used or acquired. The way I read this, it pertains to all traditional areas used or occupied by Indigenous people, even those not currently owned by them. This would lay a groundwork for tribes to expand their management regime on other lands other than the ones that they currently own. Indian forest management is emerging as a viable option for non-tribal lands. Virtually every tribe in Western Oregon lays claim to a large area, broad swaths of land. These lands, while not legally in tribal ownership, remain historically and culturally significant to all Western Oregon tribes. And federal law, in fact, already authorizes tribes to manage them. The Indian Self-Determination and Education Assistance Act authorizes tribes to assume performance of programs, services, functions, activities within the Department of Interior. And a lot of these lands are owned by the Bureau of Land Management and the Bureau of Interior. The problem with that program is that it is discretionary on the part of the Bureau as to whether or not they grant management. And it does not allow tribes to utilize the revenue that would come from management of those lands to offset their costs, actual costs. There also is a Tribal Forest Protection Act that authorizes tribes to manage adjacent and nearby lands under certain circumstances. That law has not been heavily used to date by tribes, and in fact, the Intertribal Timber Council is researching why that is not being used. So the Coquille tribe has previously proposed that it could manage a discrete segment of federal forest lands and share related revenue with Coos County in Oregon. These lands are called the Coos Bay Wagon Road lands. But to do this is going to require legislation. And anything like this is going to require legislation. legislation because you have to address issues of environmental responsibility, what environmental standards apply, cost and revenue allocation, provisions to encourage governmental cooperation, how we hold someone responsible for the choices they make. Something new is needed if we want to truly explore what tribal management could do for our environment and our economy. I think that in light of Article 26 and the National Policy of Tribal Self-Determination, the federal government could advance a pilot project to test tribal management of a small area of federal lands. There will be challenges with this. As Mr. Echohawk mentioned, local residents view, sometimes view international law suspiciously. We see that in the area where we live. There's some skepticism of the validity of international law. Oftentimes local residents view these lands as their own. These are things to be overcome. In the end, who do we want to manage our forests? Congress answers to popular sentiment, political ebbs and flows. State and local government leaders come and go, as do their priorities for revenue generation and environmental protection. Only tribes have always been here and will always be here. And they're motivated not by profit, not by re-election, but by ensuring the long-term livability of their communities.
First, let me thank Mr. Foster and everyone else for coming. Thank you to the panelists before me. It's great to be a part of this. So I'm going to tell a story, a quick story, hopefully, about a road in Bolivia. And it's amazing that themes that I'm going to hopefully bring out through this narrative will resonate with some of the themes that have been identified by Walter and Brett, even though it's thousands of miles away in a very different cultural, political, and legal context. Bolivia is an interesting case because Bolivia, UNDRIP, this document we've been talking about, it's non-binding, is in fact binding. It's law in Bolivia. Now, in the Bolivian case, there was an act that made UNDRIP law that basically said, yes, this is national law. In the Bolivian case, that probably wasn't as momentous of a change because Bolivia was and is a party to the ILO Convention 169, which contains a lot of the basic principles that UNDRIP was built upon. One of the principles that is very prominent in UNDRIP is the idea of free, prior, and informed consent. And I want to just read two articles in particular. They're short, but they kind of really get at this idea. And they're central to this road story that I'm going to tell. So Article 19, so this is from UNDRIP. Article 19 says, states shall consult and cooperate in good faith with the indigenous peoples concerned through their own representative institutions in order to obtain their free, prior, and informed consent for adopting and implementing legislation or administrative measures that may affect them. The other article I want to read really briefly is Article 32 says, states shall consult and cooperate in good faith with the indigenous peoples concerned through their own representative institutions in order to obtain, again, their free and informed consent prior to the approval of any project affecting their lands or territories and other resources, particularly in connection with the development, utilization, or exploitation of mineral, water, and other resources. In both of these articles, we see this concept of free, prior, and informed consent, but before we get this term, free, prior, and informed consent, or FPIC as it's sometimes called, we get this preceding clause which says the government shall cooperate and consult in good faith in order to obtain free, prior, and informed consent. So There was some debate initially about what this means. Does this mean that communities that can claim this right in Bolivia and around the world have a veto right, that consent must be obtained? And I think the consensus, certainly as it's been interpreted, it's not a veto right. Instead, the government has a duty to consult with the goal of obtaining FPIC, but not necessarily a requirement to obtain FPIC. And it's an important distinction because if it were interpreted the other way, that would be significantly more power, I think, for indigenous communities. Back to the story of the road. This is a story which is ongoing right now, which is happening in Bolivia right now, and has been happening actively for the last probably 4 or 5 years. But really, like so many of these big infrastructure projects, you got to go back 100 and 150 years. So in Bolivia, there are departments. Departments are like states. And 2 departments in particular, Beni and Cochabamba, never had a road connection. So it'd be like if you wanted to go from Portland to San Francisco, but to do that, you had to go through Eastern Oregon down to Nevada and then swing back around and finally get to San Francisco. So in colonial times, the local Spanish governor said we should make a road to connect these 2 areas, 2 reasonably big-sized cities. And this has always been a sort of dream of the colonial governors, and then every national government since in post-colonial times. It remained a dream. Until 2005, when current President Evo Morales was elected. And he was elected on a platform that prominently featured indigenous rights and sustainable development. And in his first term, secured a new constitution and also, as I mentioned, passed a law which made UNDRIP national law. So the road project was ramped back up in the Morales presidency. And the government, prior to consulting anyone, well, I should say, where's the indigenous populations involved here? Bolivia is an interesting country. The majority of Bolivian residents self-identify as indigenous. So that's sort of one point. The second point is that this road was planned to connect these 2 departments and to go right through a national park and protected indigenous territory, both 2 in 1. That's called Tipis, as George mentioned in the beginning. And this park is inhabited by 2 tribes, about 50 villages, and the road was going to split the park in 2. And the government, after having made UNDRIP law, didn't consult with the peoples in this park prior to signing a contract with a Brazilian firm to build the road. And construction of the road starts not in the park, but sort of a pincer action outside of the park. So it's sort of closing in on the park. And this is happening in an area that's sparsely populated, but nevertheless, eventually, it raises some issues, and there are a lot of protests. The people of the park, sentiment is split. Some people in the park want the road, some people don't. Some people in the surrounding areas want the park, want the road, some people don't. And eventually there's a march to La Paz, the capital of Bolivia, to stop the road. And it becomes a national movement. There are blockades, cities are shut down. I was there while this was happening for a week at a time. And eventually the government says, okay, we won't do the road until we do a prior consultation, right? We agree we need to consult with the people of this area before we do the road. And so that was the plan. However, the government went a little bit further. And I think this is interesting because this raises the question of, does UNDRIP, do we have to think about government use of the law, sort of changing the legal baseline to change the outcome of consultations. What the government did in the Bolivian case was it said, okay, we won't do the road, and we'll also pass a law to protect the park and the indigenous territory. And it passed a law that made the park, and this resonated with something Brett was talking about, it passed a law that made the park and its protecting the indigenous territory untouchable. And at first, people thought, okay, cool, maybe that's great in the sense that the tribes, the inhabitants of the park have gotten what they wanted, but untouchable really meant untouchable. It meant no sustainable forestry, no ecotourism, maybe even not subsistence fishing and hunting within the park. And so it looked like the government was giving people more than what they had asked for, more than what they wanted. A few months later, the government goes and does the consultation. And initially, the government raised the issue of, well, who do we consult? Do we just consult these 50 villages living in the park, or do we consult everybody along the route of the road? And it looked like the government was angling for, well, we need to consider everybody, right, not just the residents of this indigenous territory. That eventually went away, and the government just consulted the folks in the indigenous territory. However, even that was controversial because inside the indigenous territory, we have, as I mentioned, about 50 villages from these two tribes. They've always been native to the area. Also, inside the park and around the edges, we have communities that identify as indigenous, but they're not indigenous to that particular area. They come from the Andean highlands, hundreds of miles away, and many of them came over when the mining industry collapsed back in the 80s as part of a sort of a promotion, a government-promoted relocation program. And these people, communities, I'm generalizing a lot, but they tend to be more plugged into the market economy. Many of these people are involved in growing coca, much of which is used for traditional uses, some of which inevitably goes towards illicit uses. Nevertheless, the economics and the cultural issues are quite different. And so some of these communities were also in the park. They're called colonizers locally, and they're in the park, so they were included within the consultation. Now, anything I say from now on is really not, okay, these are the facts, but these are some of the allegations, because it's very, very tough to pin down exactly what happened. But there have been accusations that in doing the consultation, the government threatened some groups, said, hey, we were going to build a school, but if you don't approve the road, we won't build a school. We're going to build a hospital, but that depends on how your community decides on the road. There were pretty well documented instances of gift giving, right, to the other side. Hey, we're going to give you a bunch of outboard motors, and in return, right, there's a quid pro quo expected. There were also issues over, well, who should be consulted and how should the consultation operate? UNDRIP talks about using representative modalities and consulting with the representatives of the communities as sort of gives communities the power to decide how the process should work, which on the one hand seems consistent with self-determination, but on the other hand raises potential for abuse. And there were allegations, again, it's hard to know, but there were allegations of the government identifying certain maybe ex-representatives of the tribe or sort of representatives who were kind of not really thought to be representatives anymore, and the government meeting with those people and obtaining their consent on behalf of the tribe or the village, and then the village comes back and saying, no, those met with the wrong people. There were also accusations of late night meetings far away, right, when most people couldn't participate or didn't didn't know about it. The government, this consultation happened back in 2012. Government reported that about 60% of the villages within the park supported the road, and 40% were opposed. And there was a UN commission that went down and kind of disputed and questioned some of those findings. It's kind of since then sort of fizzled out. The government, the contract with the Brazilian firm that was going to build the road kind of went away due to all these delays. And this past year has been an election year, and the government announced, you know what, we're not going to continue with the road project until we eradicate extreme poverty in the area. So the government's not said, you know, that we think the consultation, the results of the consultation are invalid. I think the government's position is it is valid, and you know, if we decide to make it a priority again, we can make it a priority again. Because I think this story hopefully illustrates there are several issues with UNDRIP implementation. I'll try to end here with a couple of notes. One, Walter pointed out to me the other day, you know, these things take a long time. So I hope I'm not just sort of telling a negative story because, you know, this is fairly significant legal shift for any nation, and there are going to be lots of bumps in the road, as it were. A few issues, though, that this story, I think, brings out that I just want us to think about, right, is does UNDRIP envision, perhaps incorrectly, a clear understanding of who the indigenous group is or who the indigenous peoples are to be consulted? In the Bolivian case, it's not always clear. In line with that, does UNDRIP tend to envision a situation, which I think it does when you read it, of a non-indigenous government consulting with an indigenous people? In the Bolivian case, again, not so clear that that dichotomy just maps on. Like I say, I think the Tiffany saga also raises concern or the issue of government manipulation, potentially, of the legal baseline to change the likelihood of obtaining approval of a project, right? So we maybe need to think about the government doing things like making a park untouchable to then, right, increase the likelihood of obtaining approval. UNDRIP is a short document, doesn't address all these details, as it probably shouldn't. And you know, finally, how does gift-giving, promises of support, and threats of sort of pulling government projects gel with the idea of consultations meant to obtain free, prior, informed consent? Do those sort of background offers or threats vitiate any consent or approval that's potentially given? At some point, you know, we probably say, well, it's not in good faith. But a lot of times it's difficult to draw a line between sort of valid consultation and potentially coercion. So I think I'll end with that, and thank you everyone again.
Thank you very much to each of our speakers, and so we have time now for questions, and so I will first turn to the audience we have here. Maybe you want to have any questions they'd like to pose to the panelists? Yes, Bob.
So this is for Mr. Kenney. You said at one point that this week the tribes own the lands that they wanted to manage. That isn't really true, right? I mean, they're the beneficial owners, the legal owners in the United States, right?
If I could just repeat the question first. So the question is that, Mr. Kenney, you had we're referring to the tribal ownership of certain land, and Professor Blum is pointing out that isn't it perhaps that they're simply the beneficial owner? Can you clarify the nature of their ownership?
Sure. Yes, that is correct, that they're the beneficial.
Hopefully it works.
Okay.
Yeah, it's like it's close to it. I don't know. Well, anyway, just speak loudly.
Okay, yeah. Yes, so they are the beneficial owner of the land, and with the caveat that they didn't really have a choice about that. That they were given these lands in a system that was set up in essentially 1934 through the Indian Reorganization Act, actually in an effort to try to enhance tribal government. And so they entered this regime of trust authority, trust land ownership, because that was the tool that was available at the time, and there wasn't the political will to transfer the lands to them in fee. I can say that the tribe does perform 95% of the management responsibility on these lands, and in some ways it seems like it's the trust in name only, because you'll have the tribe on the ground doing all of the monitoring. So the tribe does water quality monitoring before, during, and after, above, at, and below every timber management activity. The tribe performs restoration activities. They prepare the environmental analyses. They prepare the timber sale contract, and they deliver it for analysis to the Bureau, who decides whether or not they'll approve it. So yes, short answer is yes, there is, the tribe owns the beneficial interest. I would liken it to something that a person owns in trust. They just don't have the legal duties that go along with being the trustee. And I think they have enough bundles of that, sticks in that bundle, that I'm comfortable saying that it's tribe owns land.
So if I could follow up a little bit. So there's two owners. We have the United States and the tribe has got an interest in managing the lands and harvesting the timber, and the United States has other interests in environmental protection and participation. So the idea is to kind of merge the two, right? Your suggestion is that there be legislation authorizing a kind of tribal environmental impact statement process, something like that. What would that look like? I mean, would public participation remain the same? Would there be citizen suits? Which court would hear the citizens? Does the tribe have something specific in mind?
So if I could just, actually maybe if you could just very briefly restate the question, because it may be difficult for the online viewers to.
Sure.
Yeah.
Sure. Correct me, Professor Bloom, if I don't get it right too. So basically, the question is, am I suggesting that there may be an opportunity for tribal environmental protection acts under which the tribe would conduct the analysis, and then how would the public be involved? How would those rights be enforced, or would they at all? I have to say that these opinions are mine and they're not those of the tribe, but I honestly find the concept of the public being able to influence a tribe's use of its own lands as deeply offensive. These are not federal lands, and if it were lands that our family member owned, or lands that another person or group owned, there is no federal interest of the public in these lands, other than that is specifically legislated by Congress. So my personal viewpoint is that they should be treated no differently with regard to environmental protection than other lands, as far as federal environmental law is concerned.
Other lands mean private?
Private lands, in that regard. The only nexus is that there's a federal official making a decision. And I challenge anybody to say how there is a greater public interest than that. Now, if you define the public as the tribe, that's a whole other category. So you have the tribe making decisions. It's a democratically elected tribal government. They're responsible to their citizens for the decisions that they make. I think it's often overlooked that there are citizens that have diverse beliefs and opinions about how the tribes should manage their own lands. And the tribe is responsible to their constituents in the same way other governments are. And so in that regard, I think we have to decide whether we're going to trust tribes to manage their lands in a responsible way. And I'd say the record is pretty good compared to other governments.
Yes.
For Mr. Echohawk, you mentioned the effort to try to adopt these UN human rights standards through the application of international law, and noted that there's been hearings in Congress, but no reported court decisions. We don't expect probably Congress to do anything in the near future. Have there been any unreported cases involving this issue where either UN standards through this international law approach appeared promising or have been unsuccessful?
So just to restate the question, up to this point, Professor Echohawk had mentioned that there haven't been any reported decisions. Have there been perhaps any unreported decisions or any other contexts in which courts have recognized in some way or drawn on the declaration in some of their judicial rulings?
No, there have not, to my knowledge, been any unreported cases. I think that the challenge for the domestic practitioners of federal Indian law is to begin thinking about an intelligent way to begin utilizing these human rights standards, because I think that our clients, well, currently under federal Indian law, none of the recognized rights by that body of law derived from the human rights principle. And that entire legal framework is bereft of the human rights principle. The foundational cases in federal Indian law expressly eschew looking to abstract principles of justice or getting involved in debates over morality when defining Native American rights. And so that has resulted in it's kind of a strange, amoral kind of a body of law that's bereft of that principle. And I think the challenge is to inject the human rights principle into that framework through very careful, I guess, strategic law development, and for our attorneys to begin informing themselves about ways to do that. Because when your client's right, be it a right to self-determination, self-government, right to culture, right to environmental protection, right to indigenous lands, arises from an inherent human right, we are then standing on very strong legal ground, because an inherent human right is by definition inalienable and indefeasible. It's the kind of right that no nation can take away. So I think the challenge is to inject that kinds of principles for all of the Declaration would define all of the rights that we now know in federal Indian law as inherent human rights, and so I think we need to look to our legal scholars, our legal theorists, our legal practitioners about how to very carefully take litigation measures to begin incorporating that kind of discourse into this legal framework. And unfortunately, that's typically the job of the public interest sector. And so far, the public interest sector of federal Indian law practitioners, Native American Rights Fund, and have really not grown in recent years. They're still about the same number of attorneys as they were back in 1970, even though today we have some over 2,600 Native American attorneys and many, many more non-Native attorneys practicing. Our public interest sector has simply not grown or kept pace with the growth of federal Indian law. And I think that they have so much on their plate, this handful of public interest attorneys, that they haven't been able to devote a law development initiative yet, to address, begin using this as a tool in litigation, which is currently available to be used to provide guidance to courts, persuasive legal authority as far as interpreting or reinterpreting our federal common law doctrines, and as part of our federal common law now to take advantage of that. So I think that that's a challenge that sits before the profession today.
So we do actually have a question that came in from one of the online viewers. So this is for Nick Fromherz. So the question is, has the Morales administration in Bolivia considered a more sustainable approach to building a road in the sense of, instead of just a conventional road, maybe something that would have less impact, some kind of underground tunnel or something, or is this not feasible given the geography of the area? So that's one question. And the second one is, has the impact of the MAS, I guess it's party, Moss's loss in the recent elections impacted in some way the prospects for TIPs?
Great questions, both. Should
I just lean into the microphone?
Okay, both of those are great questions. So the first question about alternative routes or alternatives, period, to this particular road through Tippys. There was a lot of discussion outside of government sectors about the possibility of building a road that skirts around the park. And if you look at it on a map, it doesn't seem like that would be, really clearly going out of the way. In terms of local geography, I'm less sure. The argument that was put forward by the government was, we want to follow the river. We want to follow the river. That's the easiest construction route, and that'll take us through the park. Now, again, this is a lot of allegations. People said, no, this particular route is being chosen because inhabitants of the area, not in the park, want a road that gets into the park to be able to engage in forestry and coca plantation of the ground there. I don't want to say that's right or it's wrong. I don't know. I know that there wasn't serious. I think it's fair to say there wasn't serious high-level consideration of alternatives that was delivered to the public. It may have happened behind closed doors. And then the other point is, when the consultation happened, an alternative route was not sort of presented as an option. It was, an up or down question. Do you want this road or not? The second question about the recent losses of MAS, this is Evo Morales' party, MAS, in elections. These were departmental elections and municipal elections. I think that has weakened MAS somewhat, but MAS is still, there's a big difference between losing a few cities, even if they're big cities, and losing on the national level, and MAS won with about 60% the national elections a few months ago. So I don't think the landscape has not changed dramatically.
Thank you. So I forgot to mention that question was from Colin Kombache, and I apologize if I got that pronunciation wrong. Let's see. So we have another question. This one is from Professor Lucille Moussan at Cardozo Law School. She wants to know, this, I guess would probably be most appropriate for Walter, is there a U.S. commission or committee that is investigating adopting UNDRIP and U.S. legislation? And if so, who has appointed the members of that commission?
There is not such a commission here in the United States. Canada, for example, has a National Human Rights Commission, and that is following this UNDRIP issues very closely in Canada. But I don't, we don't have anything of that nature here in our country that I'm aware of. And I think that in terms of implementing here in the United States, the ball is in the court initially of Native America, that is the Indian tribes, their tribal political leaders, the attorneys that represent them, the law professors that are scholars in that area, to educate themselves about this and then to develop their own proposed remedies, vet them within Indian country as to how this human rights principle and remedies may work and impact federal Indian law. And then begin to begin coaxing the government, the national government, to adopting a national plan of implementation. And in that process, hopefully working with all Americans of goodwill and the larger society, all sectors of civil society, to do that on a good faith and collaborative process, that we might all work together and stride into the light of justice, together, that we might all stand, in the human rights realm together here as part of America's unfinished nation building.
Yes, question over here.
Yes, for Mr. Fromherz. Does the Bolivian government have a process or procedure already in place for consultation prior to consultation that they did? And if so, is it comparable to what the United States has?
So the question again is, what sort of framework did the government have in Bolivia for dealing with consultations and legal framework, and how does that compare to the framework in the United States to the extent you're familiar with it, or anyone else here who might be able to address this?
The framework really isn't comparable. So I think the answer to the first question is yes. UNDRIP didn't sort of signal the sort of first time that a consultation requirement or process would be used in Bolivia. That's something that's been used and has been sporadically, we might say, as part of national law before UNDRIP, at least going back to when Bolivia ratified the ILO Convention 169, which contains a similar rule of prior consultation with indigenous peoples. However, in terms of the process, I know it looks nothing or very, very little like, for instance, a NEPA consultation process. I hesitate to. I've seen some of the documents associated with the consultation process around TIPNIs in particular, and I've seen some videos, and it's been kind of largely informal town hall style meetings where representatives of the community then sort of sign a statement saying that they approve the proposal. I think it looks, you look at the documents and you feel like a lot is lacking in terms of ensuring that, okay, is everybody understanding what is going on? Is it being done in an appropriate language? It's supposed to be done in a language, in the native language as well as in Spanish. Questions about whether that happens all the time.
All right, well, unfortunately, I think we have come to the end of our time. So I want to thank everybody for being here, as well as those of you who watched it online live or who will watch it in the future. Also want to just very quickly thank folks at AZL, including Wes Frist and Amy Morello and Jimmy, for their help with organizing this and promoting it, as well as speak with her, Melissa Clark, Lucy Brown, Ryan Montgomery, and Craig Lido for logistical and technical support. And hopefully this will be the first of a series of events we will be organizing under the auspices of the Rights of Indigenous Peoples interest group. Very much.